I don't think one should be particularly surprised at the final verdict which has come today. Well, I don't think anybody wanted any convictions in the matter. Well, I don't think anybody wanted any convictions in the matter. The CBI had a very selective role to play, and this is an entire process. Two FIRs were filed. They were sought to be prosecuted in separate courts. There was a technical defect in as much as they hadn't taken the permission of the High Court. So therefore, when the matter went to the High Court first stayed the trial, then they thereafter struck down on one part of it. The CBI did not file an appeal. You see, a lot of all this happened during the NDA regime of Mr. Vajpayee. Thereafter, there was a change of regime, but still there was no seriousness in prosecuting it. The CBI never filed an appeal. And if you actually take the timeline, this case proceeded towards a conclusion only after the 2017 judgment of the Supreme Court, which combined both matters, said you take the evidence which has already been recorded, continue the case from there, and then deliver a verdict. What the Supreme Court has achieved by the 2017 verdict was to bring the matter to some conclusion. Whether that conclusion, whether the verdict at the end of the process satisfies anyone or not, that was not for the Supreme Court at that stage to do. But the entire period of 25 years where there was all this pussyfooting was obviously did not inure to the benefit of the prosecution. It inured to the benefit of the defense. Delay is a well-known defense tactic, and I don't think one should be particularly surprised at the final verdict which has come today. Material which is in the public domain is not necessarily evidence, as you well know. Evidence is that which is brought properly under the Evidence Act before a court of law. I have known so many so-called foolproof cases failing for want of a necessary process of putting the evidence before the court. You may remember that of the three people who were released at Kandahar, one was a terrorist called Ahmad Umar Saeed Sheikh, who later on in Pakistan killed Daniel Pearl, etc., etc. When he was tried in an Indian court in Meerut, the prosecution failed to bring in a notification showing that the Hizbul Mujahideen was a banned organization. Therefore, he was not ultimately convicted under TADA, but only under the Arms Act, and only for 3 years. There was another case which was pending in Delhi, and in between Kandahar happened and all that. My simple point is this, that there may be realms of material out there in the public domain, but unless a prosecutor brings it on the record through a process known in law, the court is not supposed to take cognizance of it. Did the prosecution do it? Did the prosecution do an honest job? Are all questions which would naturally rise in the circumstances, and unless you see the judgment and the record in the case, you can't, it would be unfair to take a call. See, I'm a man of law. I'm not a man of politics. Anybody can spin anything politically say, okay, look, this was not proven. But this is a fine line in politics which goes on and on. There was a lot of suspicion, but proof in a court and proof beyond all reasonable doubt today has not happened. But you must remember that there is an appeal system. You must remember that in the Jessica Lal case and even in Priyadarshini Mattu, there were acquittals at the first instance. In Priyadarshini Mattu, the trial court judge said, I am convinced that he has done it, but still there is no evidence. How an appellate court will look at it and look at the material, I would not hazard a guess today. Let's take the 2G case. There has been an acquittal, and the trial judge said, I've been waiting in court for so many days and nobody came up with evidence. Now that matter, the appeal is pending in the High Court, and to decide whether leave for appeal should be granted, that hearing has not happened. I suspect something similar will happen in this case. There may be a decision taken, or that an appeal will be filed, but I do not. Even that decision will be a tough call to take. There will be many pulls and pushes. If such a decision is taken, and if it is filed, as to when the Lucknow bench of the Allahabad High Court will hear it, the law's proverbial delay has its own lessons to be drawn.